All right, now let's get analysis. We're now joined via Zoom by Elton Hart from the University of Johannesburg's Law Clinic. Thank you so much for your time this afternoon, Elton. It's not a blow for the president, so says his spokesperson there. Before dismissing the president's bid to challenge the report, the Apex Court concluded, of course, that no case had been made for exclusive jurisdiction of direct access. Unpack what this actually means for us, and what it speaks to, and of course, your reaction to the ConCourt's ruling.
No, indeed, Anati, it's like if you look at Section 167 of the Constitution, there's two instances where the court has jurisdiction, where you have direct access, and also where the court has exclusive jurisdiction, and it's dealt with in Section 167, subsection 3 and 4. And it stipulates exactly under what circumstances you have direct access, and it stipulates for which matters the court has exclusive jurisdiction. Now, and I have to agree with the spokesperson Magwenya for the presidency at this point in time, is that the merits of the case was not touched on. The court just said to the president, listen here, president, that is not a matter for which you, the court has exclusive jurisdiction and which warrants direct access. You have other courts at your disposal to listen to this matter. And on top of that, that it's not of such a nature that we need to have it in front of us. You can approach a high court. So the president can approach a high court to say that I find problem with the findings and I want it to be taken on review. And that's what the court is or was seized with today, and not necessarily delving into the merits to say, is that interpretation that the president wants to rely on, saying that there's a difference between evidence and information, and it's an interpretation thing, and it's only in the exclusive jurisdiction of the Constitutional Court, which is incorrect. The High Court can also look at the interpretation of a word or document and come to a conclusion. If there is constitutional issues raised, then it can just be sent later to the Constitutional Court for confirmation. So I think whoever advised the president to go for direct access, that advice was made in law.
Yeah, I was about to ask. I mean, one then imagines that his legal team, and of course that's the president's legal team, would have anticipated something like this. And that's obviously the court not making any findings on the merit of the president's case. And you obviously mentioned the alternative now is that he has to turn to the High Court. Is it something that you think that he will do as a president? Because, I mean, if you think about that report, it was a report that was damning, the Section 89 probe, and it made some adverse findings. So one would only imagine that President Cyril Ramaphosa would want to maintain his case of innocence.
Now, obviously, the president is disputing the fact that he says that the panel who actually looked into the Phala Phala scandal sort of relied on allegations and did not find concrete evidence to say that he has flouted the condition or the provisions of the Constitution. And they just worked on the affidavit and statements given by the complainants, if one can put it that way. And he said that the panel then was flawed in their finding to say that this information can be treated as evidence. But obviously, if you go into such a thing to say that this is allegations against me, then you have the right to approach a High Court, and you don't have the right to just jump immediately to the Constitutional Court because by the president of this country. You still need to abide by the laws of this country and say, go to the High Court, let them deal with this matter. Do they make a finding against me? I have a right to appeal to the Supreme Court of Appeal. If I'm not happy with their decision, I go to the Constitutional Court, which is the highest court pertaining to all matters, especially when there is a constitutional aspect to it. So in certain instances, the buck will stop at the SCA. But yeah, I think the president's advisors should have foreseen that this is the stance that the court should have taken, and they should have advised him accordingly. And I think that's why the judges at the Constitutional Court was maybe also not willing to give a cost order against the presidency, because then they will actually punish the public, because a cost order against the presidency means that the taxpayer will pay the money. So I think that's why they also steered or veered away from the cost order against the president for the dismissal of this application.
Elton, I know that there is some form of delay, in our connection, but let me ask you this final question. What is then likely to play out on the legal sphere? Because we obviously know that, the EFF in January also filing papers in the ConCourt about this particular matter, opposing Ramaphosa's bid to then review the report itself. And of course, the African transformation movement has been going to court, including the High Court in the Western Cape, about this particular matter. Just talk to us about the scenarios we are likely to see in the next coming weeks.
Now, obviously, I think that there was this preliminary report by a panel that was constituted by the Speaker of Parliament, who's actually the head of Parliament, to say, listen, yeah, there's these allegations. I want you guys to first investigate if there's something. So for me, I think then the Speaker of Parliament wants the report, and it's your panel that you've appointed, say, listen, yeah, I would then set up an ad hoc committee, the similar to what's currently happening in the Section 194 with the current public protector, to say, let's have this ad hoc committee and see if the president actually, and get people to come and testify to see if the president has flouted the constitution, and then you can go back to the House and say, listen here, the ad hoc committee has made a finding, be it adverse or favorable, and if it's favorable to the president, to say that he did not flout the constitution, that's the end of the matter. If it's adverse, then they will have to now go to the parliament to vote. But we now know in December, there was a vote already, and the ANC has got a 2/3 majority in parliament. So they're not going, or the opposition doesn't have a 2/3 majority to actually say that we are going to adopt and proceed with Section 89 inquiry against the president. So then it will mean, if the president still feels that he wants to vindicate himself from the findings of the panel, he needs to go to the High Court and go and say to this panel was irrational in their findings, they did not consider, and then the High Court needs to make a decision if they agree with the president or if they agree with the panel. So that's how I see it. But the hard work was done by EFF and the ATM in being persistent in actually saying, listen, yeah, let's bring this to court. Obviously, it's not yet with the merits, but we'll have to see how the merits play out, if there's merits from the arguments advanced by the ATM and the EFF.
All right, Elton, thank you so much for your time this afternoon. Really do appreciate it. Elton Hart from the University of Johannesburg's Law Clinic, commenting there, of course, the presidency saying the judgment by the ConCourt to deny the president direct access to the Apex Court is not a blow to the president at all.